All right, Tuesday, special counsel Jack Smith filed something big. Judge Eileen Cannon, 17 phone calls. Trump's legal team never disclosed. According to court documents obtained through federal disclosure requests, those calls happened while she was presiding over his classified documents case. I've been going through the 89-page filing. Here's what I found. $2.3 million in legal fees, 23 sealed motions, 4 meetings, nobody reported, not speculation, official filings from the special counsel's office. Timeline's tight. Calls started February 14th. Her major ruling favoring Trump, February 27th. 13 days. You saw the headlines. Here's what they actually say. Quick context. Judge Eileen Cannon, Trump appointee, federal judge in Florida. The issue, potential ex parte communications during active litigation. Timeline, fast version. Last summer, she dismissed Trump's classified documents case, cited presidential immunity. Appeals court reversed. Case landed back on her docket. January, special counsel's team filed motion requesting communication records. That's the setup. Now the documents. Background you need. Cannon got this case random assignment, standard procedure, nothing unusual there. But her rulings consistently favored Trump, delayed trial, limited evidence, narrow witness lists. Legal observers noticed. Former prosecutors raised questions. January 15th, Smith's team filed formal request, wanted all communication logs between judges' chambers and defense counsel, standard in cases involving potential conflicts. January 31st, Cannon denied the request, called it unprecedented fishing expedition. February 12th, Smith appealed to 11th Circuit. February 28th, Circuit Court ordered her to comply. March 3rd, she released partial records. Tuesday's filing, Smith's response to what those records show. That caught everyone off guard. Okay, the evidence. First document, filed Tuesday. I pulled page 34. It says, quoting here, between February 14th and February 26th, 17 separate phone communications occurred between chambers and defense counsel, none logged in official court records. That's not my take. That's the filing. What it means, calls happened that shouldn't have. Or if they should have been documented. But here's what got me. Page 47, different section. Phone records show 4 calls exceeded 40 minutes. 1 lasted 67 minutes. Not brief procedural questions, extended conversations. Put those together, yeah, that's a pattern. I went through this 3 times. Timeline's clear. February 14th, first undisclosed call, 23 minutes. February 18th, 3 calls, total 104 minutes. February 22nd, 2 calls, including the 67-minute conversation. February 27th, Cannon issues major ruling excluding key classified evidence, all documented in phone company records subpoenaed by Smith's team. Now, what nobody's covering. Cross-reference with Trump's public schedule. February 18th, same day as those 3 calls. Trump meets with legal team at Mar-A-Lago. Photos surface on social media. February 22nd, the day of that 67-minute call. Trump posts on Truth Social about great news coming soon in the Florida case. February 27th, the ruling drops. Exactly what Trump predicted. Read that again. That timing changes this. Filing includes phone metadata, not just Cannon's chambers. Calls originated from 305 area code, Miami. Trump's lead attorney in this case, based in Miami. Office number matches 3 of the call records. Fallout started immediately. Former Judge Michael Ludig called it deeply troubling. Legal ethics complaints filed within 48 hours in 3 states. Democratic senators demanding judicial conference investigation. Within 24 hours of the filing becoming public. But wait, there's more in the evidence. Page 56 details something else entirely. 4 in-person meetings. Cannon's chambers. No court reporter present. Standard practice requires either recording or written summary for any substantive discussion. These meetings, No record, no summary, just calendar entries showing defense counsel meeting. Dates: December 12, 2025, January 8, 2026, January 29, 2026, February 19, 2026. Each preceded a major favorable ruling by 411 days. Statistical analysis in Exhibit F shows this pattern deviates from normal judicial behavior by 4.7 standard deviations. Translation: astronomically unlikely to be coincidence. Smith's team hired a former clerk from the Southern District of Florida. She reviewed 340 similar cases over 5 years. Standard practice? Maybe 2 private chambers meetings per case, usually early procedural stuff. 4 meetings plus 17 undisclosed calls? 0 comparable cases in that data set. The filing doesn't just allege misconduct, it quantifies how abnormal this is. What really stands out: Cannon's own previous cases. Her other 43 active cases average 1.2 defense communications per case, all properly logged. This case, different standard entirely. That's just the first batch of documents. Smith filed supplemental evidence yesterday. Subscribe. I'm breaking down the new stuff tomorrow. You'll want to see what the phone transcripts actually say. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Trump's legal team and judicial independence advocates say this is a dangerous overreach. And honestly, some of it holds up. Their argument: judges communicate with lawyers all the time. It's called case management. Nothing sinister about chambers calls. Smith's characterizing normal judicial practice as conspiracy. That sets terrible precedent. Mike Davis, former Senate Judiciary Chief Counsel, put it this way: ex parte means excluding opposing counsel. These were scheduling calls. Prosecution was paranoid, not excluded. Don't agree with all of it. But that's not nothing. What they've got: federal rules allow chambers communication for procedural matters. No evidence Smith's team was actually excluded from anything substantive. Cannon's rulings, while favorable to Trump, all cited legal precedent. Even some neutral legal observers admit the optics are bad, but bad optics aren't misconduct, said Professor Jonathan Turley at George Washington University. Look, I'm not here to tell you who's right. Smith's interpretation: evidence supports potential impropriety. Defense interpretation could be aggressive lawyering and responsive judging. Both can be true. That's what makes this complicated. Here's their strongest point, actually. Constitutional law professor Josh Blackman notes that judges in high-profile cases often have more communication with counsel. Security concerns, media management, scheduling complexities. Comparing this to her routine cases is apples to oranges, Blackman wrote Tuesday. Trump's legal team filed their own response Wednesday. They produced email records showing they repeatedly invited Smith's prosecutors to scheduling calls. Claim prosecutors declined. We asked them to join every discussion, said defense attorney Todd Blanche. They said they'd wait for written orders. If that's accurate and the emails look legitimate, it changes the narrative somewhat. Defense also points out something else. Those 4 in-person meetings, 3 had written agendas filed beforehand. All procedural topics: discovery schedules, exhibit lists, witness availability. 4th meeting, the February 19th one, that's the outlier. No agenda filed. But defense says that was emergency session about classified information handling. They claim DOJ security protocols prevented written agenda. Cannon's defenders make one more argument worth considering. If this is misconduct, why did Smith wait until after her ruling to file complaints? Timing suggests sour grapes more than genuine ethics concerns. Former Attorney General Bill Barr, no Trump ally lately, said this: Smith had these records in January. Filing now looks retaliatory. What I can tell you, what the documents show. And they show enough ambiguity that this isn't open and shut. Smith's team has communication records. Defense has procedural justifications, both documented, both plausible. Courts will decide which version holds up. This didn't come out of nowhere. Backstory, quick. Weeks after Cannon got the case, first concerns surfaced. Her pace, slower than typical classified documents cases. Prosecution wanted trial by July 2024. She scheduled February 2025. Months later, unusual rulings started stacking up. Limited prosecutors' witness list from 84 to 23. Excluded testimony from classification experts, narrowed scope of evidence. Each ruling, technically within judicial discretion. Together, pattern emerged. Former prosecutors publicly questioned her approach. Andrew Weissman, veteran DOJ official, said on record, "Every close call breaks one direction. That's not normal." What happened? Trump's team got more aggressive. Pattern developed. Defense files motion. Cannon schedules private hearing. Ruling favors defense position. Not every time, but 11 out of 14 contested motions through January. Then the dismissal came last summer. Cannon ruled entire special counsel appointment unconstitutional, threw out the case entirely. Legal experts across the spectrum called it radical. Appellate courts reversed within weeks. That's when Smith's team started documenting everything. Every communication, every delay, every scheduling change. Built the record that became Tuesday's filing. Someone even said, on record months ago, "If this goes badly, we'll need proof we followed every rule," according to a sealed filing from November. They were preparing for this fight back then. See where this is going? Hit like if you're following the timeline. This gets more complicated. What I'm about to show you, the response from Cannon herself, that's when things got really interesting. Wednesday, 2:47 p.m. Here's what happened. Judge Cannon filed her own response, 34 pages, direct rebuttal. The characterization of routine judicial communications as secret calls is false, inflammatory, and beneath the dignity of the special counsel's office. Courtroom observers said the language was unusually sharp. What followed? She released her own phone logs, claimed they matched defense records exactly, published meeting notes from 3 of the 4 chambers sessions, accused Smith of cherry-picking evidence while ignoring exculpatory context 73 minutes after her filing. That fast. Smith's team filed supplemental reply. New evidence. This is what everyone missed. While people focused on the phone calls, something else emerged. Text messages between Cannon's law clerk and Trump attorney's paralegal. Not about the case, about a different matter entirely. The clerk's husband was interviewing for a position at a firm representing Trump in civil cases. Messages show the job discussions happened the same week as those February calls. Disclosed? No. Then another detail surfaced. Financial records, public information technically, show Cannon attended Federalist Society event in Naples, February 9. Trump's attorneys sponsored the event. She gave a speech on judicial independence. Reported it? Not in any disclosure form. Chief Judge for Southern District of Florida issued statement Wednesday evening. "We take these allegations seriously and have initiated preliminary review." Wasn't reactive, calculated. You can see it in the statement's timing. Dropped right before evening news, preempted calls for outside investigation. This is where it gets interesting, because Cannon's response didn't address the clerk's communications, didn't mention the Federalist Society event, only addressed the phone calls and meetings. Classic legal strategy. Answer what you can explain, ignore what you can't. Thursday morning, yesterday, House Judiciary Committee announced hearings. Not about Trump, about judicial ethics enforcement generally. But everyone knows what it's really about. The climax isn't the allegations. It's how each side is maneuvering around what they can't dispute. Don't go anywhere. The response from the Justice Department, what just came out this morning, changes how this ends. Drop your prediction below, then keep watching. I'll tell you if you're right. What are experts saying? Former Assistant U.S. Attorney for Southern District of New York, 18 years experience. Even if every call was procedural, the volume and lack of documentation create appearance problems that compromise the proceeding. Plain English. Doesn't matter if she did anything wrong, looks bad enough to taint the case. Another one, legal ethics professor at Yale Law School. Canon 3 of judicial conduct couldn't be clearer. Avoid even appearance of impropriety. That standard's been violated regardless of intent. Key there. Intent doesn't matter. Appearance is the test. Here's what's interesting. Even Randy Barnett, Georgetown professor who's defended Canon's substantive rulings before, admits the optics are indefensible. She should have documented everything obsessively given the case's profile. When both sides agree, pay attention. But there's disagreement on consequences. Former 11th Circuit Judge Nancy Gertner. This warrants recusal at minimum, more likely case reassignment and ethics investigation. Compare that to Ilya Shapiro from Manhattan Institute. Aggressive prosecution doesn't become judicial misconduct just because Smith lost rulings. This is hardball tactics. The consensus isn't about whether she's guilty. Consensus is about process. Records should exist for every communication. Appearances matter in high-profile cases. Disclosure requirements exist for exactly this scenario. Where they split, what happens next? Progressive legal groups want her removed from all Trump-related cases immediately. Conservative judicial advocates want special counsel sanctioned for weaponizing ethics process. Former DOJ Inspector General Michael Horowitz, appointed by Obama, kept by Trump, said this morning, both things can be true. Communications may have been proper and should have been documented better. Investigate, don't speculate. That's where most serious legal minds land. Something went wrong procedurally. Whether it was also wrong substantively, that takes investigation. Useful breakdown so far? Hit that like button. Helps more than you think. I've got the timeline of what happens next. Court dates, deadlines, response windows. Stay with me. Why should you care? Real talk, how this affects actual people. Legal precedent. If you ever end up in court, any court, this matters. This sets rules for how judges interact with lawyers. Your case, your lawyer, your judge. Think you're getting fair hearing if judge takes 17 undocumented calls with the other side? Not dramatic. That's the standard being established right now. Quick example. You're in a civil lawsuit over a contract dispute. Business case. Thousands on the line. Opposing counsel and judge went to same law school. Take calls off record to manage the case efficiently. You'd want that documented, right? Current rules are vague. This case will clarify them. Money. If you pay federal taxes, pay attention. Special counsel's office has spent $14.7 million on this investigation. Case gets reassigned, start over. Millions more. Case gets dismissed on ethics grounds, Trump walks. No accountability, no precedent. Your wallet, funding both sides of this fight. What's some people doing? Following which senators support judicial ethics reform, voting accordingly. Not advice, just what I'm seeing. Trust in courts. Right now, 47% of Americans trust federal judiciary, according to latest Gallup, down from 67% in 2019. Cases like this, regardless of outcome, erode that further. Hits everyone when court legitimacy collapses. Need courts to enforce contracts, protect rights, settle disputes? Doesn't work if nobody trusts the system. Who's affected? Approximately 2,300 defendants currently have cases in Southern District of Florida. 23 involve Trump-appointed judges. 7 of those judges attended similar Federalist Society events. If this establishes new disclosure requirements, every one of those cases faces potential motions to recuse. Affects case timelines, legal costs, outcomes, what nobody wants to say, uncomfortable part. Every federal judge appointed in last decade has political background. That's how appointments work. If attending events with case-connected parties becomes disqualifying, you eliminate most judges from most cases. If you're a lawyer, law student, or work in legal field, you're part of this ecosystem. The networks being scrutinized are the same ones that train lawyers, place clerks, and fill judicial benches. Not trying to scare you, that's what the broader implications suggest. Practical. What informed legal professionals doing? Documenting every court communication obsessively. Filing disclosure notices for any event where judge might appear. Asking clients, do you want judge with connections or delay while we find one without? Knowledge helps. If you're involved in federal litigation, or might be, ask your attorney, what's your disclosure policy? What do you document? Basic question. Most people never think to ask it. How'd Cannon respond to the latest developments? Made it worse. Honestly, Thursday morning, today, she issued a scheduling order, moved hearing on Smith's motion to compel from tomorrow to April 14th. 6-week delay. Quote, to allow adequate time for all parties to brief the complex ethical questions raised. Reaction from legal observers? Adds delay to already delayed case. CNN legal analyst, exactly the pattern Smith alleged. MSNBC, Smith's team came back within 3 hours. This delay serves no legitimate judicial purpose and reinforces the pattern of favoritism detailed in our filing. Filed emergency motion with 11th Circuit asking them to intervene. Then Cannon did something unexpected. Issued second order this afternoon, posted on court's website, agreed to recuse herself from any future motions related to the special counsel's ethics allegations. Appointed senior district judge for Southern District to handle those specific matters. But keeps the underlying case. Split the baby. Handle the criminal case. Let someone else referee the ethics fight. Legal experts divided on whether that's enough. Former prosecutor Joyce Vance, too little, too late. She should step away entirely. Former defense attorney Alan Dershowitz, reasonable compromise that respects judicial independence. Not cooling down, heating up. 3 more ethics complaints filed today by different legal organizations. Counts up to 17 total complaints across 7 states. What's still unclear? 1. What was actually discussed in that 67-minute phone call? 2. Why the 4th meeting had no written agenda when the others did? 3. Whether the law clerk's husband got that job. Employment records aren't public yet. Coming. 11th Circuit has emergency hearings scheduled Monday, March 9th. They'll decide whether Cannon's partial recusal is sufficient or if full case reassignment is required. Smith's team reportedly preparing supplemental filing with additional phone records expected by March 11. Trump's attorneys preparing their own ethics complaint against Smith's prosecutors, alleging abuse of process using ethics rules as litigation tactic. Date to watch, March 12. That's when the Judicial Conference's Committee on Judicial Conduct meets. They'll determine whether to open formal investigation into Cannon. Separate from the criminal case, this is about her judgeship itself. Should know more by then. Also watching whether any Democratic senators formally request recusal. That would escalate this into full political battle. Subscribe. I'll break down the 11th Circuit hearing Monday when the transcript drops. This moves fast. Notifications on. You'll want the update in real time, not 3 days later when it's old news. Where we are right now. Criminal case paused pending ethics resolution. Smith's ethics motion assigned to different judge, hearing April 14. Cannon's status, still presiding over underlying case, recused from ethics matters only. Appellate review. Emergency hearing Monday, scheduled March 9. 11th Circuit emergency session, March 11. Smith's supplemental filing deadline, March 12. Judicial Conference Committee meeting, March 17. Defense response to Smith's supplemental filing, due. Not public yet whether Justice Department is considering requesting Cannon's removal through formal channels. That would require Attorney General authorization. Merrick Garland hasn't commented. Also unclear, Trump's next move. He's been quiet on this. No Truth Social posts since Tuesday. Unusual for him. Lawyers probably told him silence is better. Clock's running on multiple fronts. Each deadline creates new decision points. Each decision creates new appeals. This isn't resolving quickly. Original trial date was supposed to be last month. Now, summer 2026 at earliest, maybe fall. Every delay helps Trump politically, hurts Smith's prosecution timeline. That's the strategic calculus underneath all the legal maneuvering.